count on that one. I think that I just looked at that.
Oh, okay.
Welcome back to Time Served, the channel that scans the docket so you don't have to. I'm your boy Phil, and we are 100 away from 20K. I thank you for your continuing support as the channel keeps growing and growing. From the bottom of my heart, I say thank you. So without further ado, let's get rolling into today's clips. We have clips out of Wyandotte, Jefferson County, Judge Boyd, Judge Bryant, and a surprise main event that I promise you will listen to more than once and will probably become the most replayed part of this video. Don't forget to hit that like and subscribe, set your notifications to all, and never miss the Daily Docket. I'm your boy Phil. Court is now in session. Let's roll, nerds.
Yeah, I need a pad, I guess. Who's this? Adrian White. Twenty-two 39940 is now called the state of Texas versus Adrian Wright, who is present with his attorney, Mr. Dusler. Go ahead.
Your Honor,
This is an announcement, right?
yes, sir.
Yes.
There's actually two other cases as well. I've talked with Mr. White at length, and he seems fairly confused. We previously filed a motion for a examination by Dr. Griffon. He gave us a report dated January 2nd, 2023, stating that he's competent. I still have a lot of difficulty getting him to comprehend the nature of the charges against him.
Or at least he appears that way.
Yes, sir. He's advised me, first of all, that he had retained Kent Johns to represent him. Later, he came back and advised me today that you hired Brittany Holmes. Right? And when I try to talk to him about his cases, all he really wants to talk about is his deceased mother and getting the car back. And we just don't seem to be able to communicate the nature of the charges of what we got.
Okay. Dr. Griffon evaluated the defendant back in January, and as he does a thorough job, and he spent some time with him and deems the defendant to have borderline intellectual functioning, which may explain a lot of that you're explaining, but he is competent to proceed to a resolution of his legal issues. And he possesses the ability to conform his behavior to acceptable standards in court if he chooses to do so, with mild intellectual limitations, but not significantly intellectually deficient. This evaluation, by the way, will be made a part of the record for all purposes. And in this case, and sealed in a envelope, unless necessary for legal matters. Does anybody have anything else to add?
No, sir. I mean, I could ask for him to be examined again, but to be quite honest, he's exhibiting the same symptoms to me that he did 6 months, 8 months ago. I don't really notice any change in him or ability for me to properly communicate with him concerning these cases.
I'm going to trust Dr. Griffon's evaluation as still valid on this day. It's made a part of the record as Court's Exhibit 1 on this date and will be sealed in the appropriate sealed envelope. And it is an announcement. Where are we headed now?
I don't know, Judge. I have trouble talking to him about it. He doesn't want to enter a plea. He doesn't want a trial.
Well, then
he just wants to talk about his.
Then let's set it for
his
trial.
family.
What's next? It'll be set for trial.
I would also point out to the court there are 2 other cases that are pending against him that do not show up on
I
the
don't
docket
see those.
as well.
You know, they're in my court right now.
Yes.
Yes, sir.
It's 22-40548 and 22-404.
I don't have the files with me.
I understand.
They're state jail felonies. One is a theft of a firearm.
This is a 3rd-degree felony.
Yes.
And it's it's just crime of violence, assaulting a peace officer. And, we're going to move forward.
Okay. Mr. Wyatt, if
I can put my car in store.
if the judge is going to set this for trial, and if you want to try to get all this resolved as soon as possible, the judge, with your permission, could replace me and another attorney to replace me to help you to get the court a lot quicker and get this resolved. Is that what you would like to do today?
No, that's for trial, sir.
Yes.
If you want to get it resolved without a trial, y'all need to work that out with you. So we don't spend the taxpayers' money on something that's necessary. If you feel like we need to go to trial, then we'll set it for trial.
I ain't trying to do a battle in court.
Understand.
Unless I get sent to California, because that's probably, you know what I'm saying? It's like, you just can't.
I know he's rambling on. The court will note he's rambling on. Dr. Rapon had a thorough investigation approach with him, and this we know that sometimes the defendants perform theatrics when they're in front of the court in a matter of cleverly attempting to bypass the evaluation, but the evaluations have been done. You've talked to him long enough, and we're going to move forward. I don't see anything other than the defendant's statements, and the court has done this before and has seen people who have been deemed to be competent ramble on. But if we're not going to dispose of the case, we will set it for trial.
Understand.
All right, it will be set for trial.
Yes,
all right,
sir.
and we'll go to trial as soon as possible. Mr. Dusler here is a very good lawyer. He can continue to represent you. He can continue to represent you. It'd probably go to trial quicker if you agree to release him, but that's your call. That's your decision. What would you like? Keep him or replace him?
I ain't trying to replace.
You like him?
Oh, sure. I have 100 lawyers. I have 100 lawyers.
You do? Okay. Well, we'll continue to use Mr. Dusler then, okay? And we'll set for trial. Okay, thank you. Here's those files. And set it for trial. Sure. Next.
Correct.
I see.
And they both been there, but we need to get appointed counsel for Miss Latrice Thomas. And we were going to represent Onaya Thomas Cook.
Well, they can't be on the same camera. What? They only have one device?
Yes, Your Honor.
Oh no, somebody gonna have to get it. They're gonna have to come in person. Or one of them will have to come in person. They can't be on the same device.
I can get another device if that's okay.
No, we're gonna go ahead today. I need the complainants to turn on their videos. And then
Yes, you got it on phone.
Like I only want, let me help y'all with this. We're in court, okay? And then I gave my instructions. Okay. So I'm gonna do, so who's on the camera now? This is Miss Thomas Cook.
Yeah.
Correct, Your Honor.
All right, so I'm gonna call the cases separately, and I will allow but Miss Thomas Cook, the angle of the camera, I don't know what's going on, but I need you to kind of be sitting up like this right here. And can y'all stop? Just listen. Listen to my instructions, because how can you know that you are if I'm giving instructions? I haven't even finished giving the instructions. And I need you to be stationary, stabilize your device, and don't have it so close to your face. That's what I need. All right. And then I don't know what Miss Williams is doing, but I need you to stop doing it with your fingers. Whatever it is you're doing, Miss Williams, I need you to stop. Okay. So I'm going to call 76602, people of the state of Michigan versus Latrice Kawante Thomas. Defendant is charged with 2 counts of assault or assault and battery. Today is the date set for pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people. I also have the complaining witness present via Zoom. Ms. Hall, can you start by saying your name for the record, please?
Brandis Hall.
Thank you. And Ms. Williams, can you unmute and state your name for the record?
Dina Williams.
And yes, Your Honor, Brandon Bird on behalf of Latrice Thomas for the purpose of this pretrial.
Okay, Ms. Thomas.
Ms. Thomas. Sorry.
Ma'am, state your name.
My name is Latrice Thomas Pearson.
What's your middle name, ma'am?
Montel.
Thank you. Today is the date set for a pretrial conference. How are we proceeding, Mr. Bird?
Your Honor, respectfully, we have to ask to get appointed counsel for Ms. Thomas due to a conflict.
The court is going to continue a not guilty plea on behalf of Ms. Thomas. I'm going to set the matter for final pretrial conference October the 3rd, 2023 at 9:01. Mr. Flanagan, please submit a request to Ms. Carter for the appointment of counsel for Ms. Thomas. Did you all speak to Ms. Thomas in the breakout room?
We spoke to both of them about what was going on, but we did let Ms. Thomas know that she was going to have to get another appointed counsel due to the fact that we're
Thomas's contact information.
We do have Ms. Thomas's contact information, Your Honor.
All right. So please pass the contact information on to Mr. Flanagan so that he can pass that on to Ruth Carter. Ms. Thomas, what is it?
I'm still trying to figure out who do we give this. We have a video of the whole thing. So.
Ma'am, I don't care. I'm appointing you counsel. I'm appointing you an attorney. And we're not speaking in we's. I'm only talking about you. That's why I'm appointing you counsel. So what I'm saying to you is worry about yourself.
Okay, and my
counsel and Miss Thomas Cook has her counsel, and they will speak to her, and your lawyer will speak to you. Okay.
Okay, but I don't understand the charges that y'all have.
Ma'am, listen to what I'm saying. I am getting you an attorney.
Okay.
Your attorney will speak to you. And then you can ask your attorney however many questions you want to ask your attorney. But I am not your attorney, and I'm not going to explain it to you. You have been charged with assault and battery. 2 counts. That's easy. That's simple. That's it. Anything else that you need to know, I am appointing you a lawyer. The lawyer is going to call you, reach out to you, show up in court for you. Okay?
Okay.
All right. Mr. Flanagan, you're going to get her contact information from Mr. Bird, and we're going to pass that contact information on to the Michigan Indigent Defense Council so that they can appoint a lawyer for Ms. Thomas. Anything further with respect to this matter?
Thank you. In the jail, state your name. In the jail, state your name. Yes, sir. Yes, sir. What is your name?
Are you talking to me, sir?
I am. What is your name?
Okay, I can't hear.
Okay, what is your name, sir?
Craig Edward Swank.
All right. This is the matter of Craig Edward Swank,
I
file
can't hear you, sir.
231269.
I can't hear you.
All right, I'm going to speak louder. Does that help?
I can't hear.
He has a hearing impairment, Your Honor. There's a friend of his here in the courtroom that informed me of that.
Thank you. Contact the jail to come in and help you. All right?
If I can't hear you, I can't hear you, sir. Can this turn up? Can this turn up?
And I'll just confirm that we are not muted, so he should be able to hear us as best he can.
I can't fucking hear.
Let me put you in a different room.
Sir,
go ahead, Your Honor.
All right. Sir, this is a bond hearing, so I'm going to ask the attorneys to place their appearances on the record.
Amanda Wagner for the people.
Thank you.
Samaris Hennigan, from the Public Defender's Office for Mr. Swank.
How would you like to proceed?
Your Honor, it's my understanding that Mr. Swank does not have a mailing address, and so missed a notice. However, had every intention of appearing in court when he was supposed to. He had posted a bond and is willing to appear for his future hearings. I would ask that the court give him a PR bond. As I say, he doesn't have a mailing address. He's transient with his home. And this incident that's alleged occurred at Share the Warmth. He has not gone back to Share the Warmth since that time, is my understanding. So if he could get a PR bond with a no contact with the victim, so that obviously it'll be much easier for Mr. Swank and I to communicate once he's been released. We can discuss getting this resolved for him.
Ms. Wagner?
Your Honor, with those stipulations, I have no objection.
Looking at the file to make sure that there is a no contact, and I'm not seeing it in the file. I am going to order that Mr. Swank have no contact with the victim, Cody Lucas Strasser. He's not to be anywhere the purported victim is. He is not to have any assaultive behavior of any kind. Okay. Not to be at the victim's residence for any reason, not to have any type of weapons in his possession, and no verbal or assaultive behavior of any kind. Ms. Wagner, you said with those stipulations you would have no objection to a PR bond?
That's correct, Your Honor.
He does need to sign the bond conditions. And with that, I will grant a PR bond. He is to be at court. The next court date is September 7th, 2023 at 8:30 in the morning. Is there anything else in this matter?
No, Your Honor.
No, thank you, Your Honor.
Mr. Swank, you need to sign the terms of probation before you're released. Or signs of, I'm sorry, his bond conditions. With that, that is all in this matter. Mr. Swank, Mr. Swain?
Yes.
You need to report to probation as soon as you're released from jail.
Report to probation after you get released from jail.
Today?
Today.
There. I'm gonna pay whatever the heck I got. Oh shit. Oh shit.
And Mr. Dagger Margosian, are you ready?
Okay. So you're not jail today.
Okay.
And then you signed something saying that you're not going to
Good morning.
Good morning.
Hello.
Hello, that's my client right there.
Yes.
Judge, it was my understanding that a case is going to go today for a murder trial.
No, you all are scheduled for jury trial.
I'm sorry?
You all are scheduled for jury trial today.
I understand.
Okay.
And I guess I just need some clarification only because if we're going to go, that's fine.
All right. So come back at 1. Could everyone please whisper?
Just one consideration I was asking for from the court is that I have a written hearing scheduled in Hayes County this morning. And it's like a really big deal because it's hard to get these dates. He's already been in jail for like a month longer than he should be trying to get this date. So if we weren't going to go at 1:30, it would be really greatly appreciated if I could head up there to take care of that situation. She's on bond.
Okay, well, she's on bond, and I don't know why she's before me chewing gum and with attitude. And that attitude is directed towards you. So why are you chewing, just 1 second, why are you chewing gum in court?
I'm sorry.
All right. So here's the thing, what you must understand. Look at me. Guess what? Everyone has a job to do. You are not his only client. The only way you can be assured that you're an attorney's only client is if you're paying them enough money so they can live off of your case. If you're paying him $500,000, I'm sure you could be his only client. But he has other clients, and he has a client that's in Hayes County. Do you understand? Yeah. All right. So there's no reason to get angry and upset with him. And actually, the first case on the docket is a murder case. Your case is not number 1 on the docket. Now, if the murder case takes care of itself, it may, then you will be there. Do you understand?
Yes.
So there's no reason to be angry with him or upset with him because you want your case to go today. If you wanted your case today, we could have went on May 22nd when your attorney was getting discovery. So, counsel, this is what I'll do. I will recall your case for tomorrow because if the other case does not go, then your case, this should be a simple trial because it's a drug case.
Yes, Your Honor.
So I think if we were to pick a jury trial in the morning on Wednesday, then this would be done fairly quickly.
Okay, I'll be here tomorrow at 9 a.m.
All right, Caroline, could you give them a reset form for tomorrow at 9 a.m. on Laura Ashby? Yes. And counsel, once she's signed the reset form, you're all excused. Show you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
I'm going to show you what's entitled Court Admonishments. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Did you sign it in all the appropriate places? You're charged with the offense of possession of a controlled substance, penalty group 1, less than 1 gram. That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years at the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your agreement. If for any reason the court doesn't follow your agreement and gives you more than you bargained for,
The fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand by entering this plea bargain agreement, you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case? Did you understand if the court were to grant your application for deferred adjudication, if any time your deferred adjudication were revoked, the court could find you guilty, sentence you up to 2 years in the state jail facility, and up to a $10,000 fine? Did you understand? Counsel, has your client been able to provide you with any defenses?
Yes, sir.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, sir.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, sir.
Ms. Caballero, has anyone threatened you, coerced you, or placed you in fear to get you? Thank you. And to get you to enter this plea? Has anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? Okay, I'm gonna need you to speak up. Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea. All right. Counsels, could you all approach for a moment? All right, we're going to go back on the record. So I'm showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes.
According to the plea, the state is recommending deferred adjudication and a $500 fine. Of course, the court will hear argument on the fine, but usually the court probates the fine. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it?
Yes.
Wait till I finish.
Oh.
And did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
Your Honor.
Outside the agreement, the state is recommending that your deferred adjudication be for a term of 2 years. There be a TAP evaluation and 100 hours of community service restitution. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
Yes, Your Honor. I submit State's Exhibit 1 in the attachments.
No, Judge, Your Honor.
All right. And state, you may be excused to continue to confer. Ms. Caballero, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right. After reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
We just request the court waive or probate the entire fine.
All right, the court will probate the fine. Ms. Caballero, how many children do you have?
I have 7.
7? Everyone, please whisper. And what are their ages?
I have 18, 17, 16, 11, 10, 9, and a 7.
Wait, 11, 10,
9,
9.
and 7.
All right, and now you have a baby on the way?
Yes, ma'am.
All right, you're 18, 17, 16, 11, 10, 9, and 7. Where are they?
My 3 oldest are with their dad. My 10-year-old and my 9-year-old are adopted by my cousin. My 11-year-old and my 7-year-old are adopted by my brother.
So because you're saying adopted, I'm assuming there was a CPS case? And what happened with the CPS case?
I voluntarily signed over my rights.
All right, what were they asking you to do that you did not do?
I didn't comply with my house service. I needed 1 room to be completed and it wasn't completed on time. So
Child Protective Services does not have you signing away your rights because of place.
I was doing everything I was supposed to. It's just, it wasn't, my house wasn't completed to get my kids back on time. So it was either the state took them or they voluntarily signed over my rights.
Child Protective Services, that's not the way it works. The way Child Protective Services works, and I would tell you, I think your attorney may have handled Child Protective. You have not?
Not never.
All right, I've handled plenty of Child Protective Services cases. And what you're telling me, that's not the way it works. You know how it works? They give you a year to get your life together to try to get your children back. And what ends up happening is you have a babysitter for free for a year. And what they want you to do is not use drugs. They want you sober. They want you to have a place for your children. They want you to be able to financially support your children. Now, if your housing is not ready, because they help you get housing.
Yes, it was just that's what it was, the placement, my housing. It was just, they said that one of the rooms wasn't completely finished because I had to rebuild my rooms.
No, let me just tell you, what you're telling me now is not true. And let me tell you why I say it's not true. Now, that may be a part of it, but that's not the whole reason, because I just told you, Child Protective Services, if you need housing for your children, guess what? They will help you get housing for your children. If there's a problem with the house where you're staying at, where maybe it's not up to code, guess what? Child Protective Services will help you get your house up to code. They do all of that. But if your house is not up to code, if you're moving a man in that you're not supposed to be moving in, and if you're still doing drugs, no, Child Protective Services is not giving your child back. And they will give you a year to get your act together. And if you have your act together within that year, but you still need a little thing, like, for example, you're telling me you need your housing, they will extend it. So the fact that all these children you have, which is 1, 2, 3, 4, 5, 6, 7, and you don't have any of them in your custody and all of them were adopted out, that tells me not only did you not do anything within a year, and the fact that they didn't extend you, because it doesn't sound like they extended you, that means that you were not doing anything. And now you're about to have another child. Are you employed?
No.
When's the last time you had employment?
5 years ago.
I'm sorry?
5 years ago.
5 years ago. And is the father of this child the same father of your other children?
No.
Who's the father of the 18-year-old?
His dad, Christopher.
Christopher?
Solis.
So Christopher is the father of 18, 17, and 16-year-old? Who's the father of the 11-year-old?
Daniel Delaveres.
Who's the father of the 10 and 9-year-old?
The same.
And the 7-year-old?
Same.
And this child?
No, not this one.
So how often are you using meth?
Well, I was using it often when they took away my kids, but when I signed them over.
See, now this is where the dishonesty come in. I asked you, why were your rights taken away from you? And what did you tell me? Housing. And I even told you, I've done CPS cases and they don't just take it away for housing. Now you come back with, I was using when they took my children away and I signed.
After I got my kids taken from me.
Yeah.
That's when I started using meth.
How many times were you using meth?
After they took my kids, I was using it on every day.
All right. And how many times were you using it before CPS even got involved in your life?
Using nothing.
Oh, so why did CPS get involved in your life?
Because my daughter had an accident.
Which daughter?
My youngest, my 7-year-old.
What accident did she have?
She fell from the second floor balcony to down the second floor balcony under the father's watch.
Okay, so let me explain something to you. Children cannot support themselves. And it appears to the court that you're just having children and allowing somebody else to support them. For example, if I were to have a child, I can't say, oh, cute baby, and then put them at Travis Park and say good luck to you. And that's what you've been doing with all of your children. You haven't raised a single one of them, and you haven't been working. So let me just tell you, I'm gonna help you with that. And I don't know why you're getting attitude with me. You haven't raised any of your children. None of your children are with you. You have an 18-year-old, 17. Here's the thing. You have an 18-year-old, 17-year-old, 16-year-old, 11-year-old, 10-year-old, 9-year-old, 7-year-old, and none of them are with you. You're not raising them. You haven't been working. You just told me in 5 years. You haven't been financially supporting any of them. Now you have a baby on the way. But I'm going to help you with that. So I'm going to sentence her to 4 years deferred adjudication. There's going to be a TAP evaluation in custody. And she's to follow all recommendations of TAP. Other than this felony case, does she have any other felonies?
Not on her, well, pending, Your Honor, or in her record?
On her record.
I believe she has one other felony.
For what?
I'm not. Unauthorized use of a vehicle. Okay, I know it's a state jail felony, Your Honor. She says unauthorized use.
All right, she's going to do a TAP evaluation in custody. All the recommendations will be followed. If TAP says that she's not to do inpatient treatment before she's released, we're going to come back to court and find out what treatment program she needs to be in with whatever treatment court that's available. You're going to get employment. Proof of it. And I understand if it ends up being a difficult pregnancy, which I hope it will not be, then we will do something about the employment. I know my mom worked until 9 months.
I know she's explained to me she's already a high risk.
All right. There's going to be proof of employment within 45 days of release. And if she can't work, then she'll need to find she need to have a doctor's excuse. There's to be no employment as a home health care provider or with minors. Once she's released, I'm going to want random field visits, 1 time per month until further notice. We're going to do the UA hotline until further notice. 200 hours of community service restitution. I'm going to order parenting classes. Make sure that's intensive parenting classes. And once she completes that, the community service hours will be waived. There's to be no unsupervised contact with minors. She is not allowed to reside in any home with minors. There's a $500 fine that will be probated. Regular reporting by Zoom or in person. How far did you go in school?
I went up to the 10th grade.
Why didn't you graduate?
Because I was going down the route path.
Okay. And do a gang evaluation on her, please. Probation, is there anything else she needs? Anything else you need from the court?
No, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? All right. And did you review the trial court certification of defendants' rights to appeal with your attorney, and did you understand it?
Yes, ma'am.
All right, we can go off the record. Here's the thing. I know you probably say Stephanie Boyd is being hard on me, but somebody needs to be hard on you, because you just can't go through this world having children and wanting somebody else to support them. And that's what's been happening. You can't go through this world and not have employment. The only people who are allowed to not really have employment are eccentric, wealthy people, because they already have the money. But you're going to have to get a job. You can't be finding yourself now. You know the reason why you don't have time to find yourself? Because you have all these children and you continue to have more children. So it's going to have to stop. You understand?
Yeah.
All right. Good luck to you.
Thanks, Judge.
Thank you.
Appearances.
Tess Ross on behalf of Mr. Snyder for the purpose of arraignment.
And Mr. Snyder, can you hear us?
Yes, I can.
Sure. Very good. State your name for the record.
My name is Damian J. Schneider.
Very good. Ms. Strasser.
Mr. Snyder intends to plead guilty to disturbing the peace this morning.
Sir, you understand if you plead guilty, I have to take the plea as it is currently written. I cannot change it. I cannot modify it in any way. In order to do that, that would be something you'd have to cover with the prosecuting attorney. You understand that?
No problem. Can I, sir? Yeah, I am guilty to that charge. But there's a lot of things that lead up to that.
Before we go on, then I need to make sure I have a basis for the plea, and then I'll let you have then you can say other things. But first, sir, you understand you have a right to a trial, and if you went to trial, the prosecutor would be obligated to prove that you're guilty beyond a reasonable doubt?
Yes, sir.
You understand that if you make a plea here today, you're going to tell us you're guilty and there's not going to be a trial of any kind? Is that your intention?
Yes, I am guilty of that charge.
Has anyone tried to frighten you or force you or intimidate you into doing this?
Absolutely no.
Has anyone made any promises to you that I'm not aware of?
No.
Are you currently on probation or parole for any other criminal convictions?
No, sir.
And are you a citizen of the United States?
Yes, sir.
The allegation here indicates this is an incident that occurred on July 10, 2023. Is that true?
Absolutely. I'm not aware of the date. It was really dark. So, on about, yes.
It's an incident that occurred in the city of Allegan, county of Allegan, state of Michigan. Is that correct?
In the city. It was at the courthouse.
Okay. And at that time, did you become involved or create a disturbance that necessitated law enforcement response?
Absolutely. I was doing donuts and wrongly, unbehaving behavior on my behalf, and I'm so sorry, sir.
All right. Very good. Are you satisfied, Ms. Strasser?
I am, Your Honor.
Very good. Other than fines and costs? Ms. Strasser?
No. We asked the court for fines and costs in this matter.
All right. Sir, fines, you've provided me with a basis to accept the plea. I will do so. Fines are $200. State costs $50. Court costs $200. Crime victim right fee of $75. That's a total of $525, and I'm going to give you 90 days to take care of that, all right?
All right. Hey, sir, yeah, thank you. And then, now, can I speak?
Sure.
So, hey, Judge, so listen, I'm going to tell you something. So, I don't know what's going on with this court system, but you got a beautiful district court. Now, we have some issues. So I've been wrongly prosecuted in the circuit court here. And then I had a judge, and this circuit court had, had the PBOs behind my back for a few years, sir. Now listen, the problem that I have with this court system is the circuit court took everything that I love and they took it away from me. They took my coaching degree from me and they destroyed me. And it's all because other people had control over me. And now I'm upset. They found me incompetent. Now I got to go deal with this stuff. So the reason why I was out there doing all that is out of anger. Hatred, and that was wrong of me. I'm gonna give it all to the Lord. I'm gonna give it all to the Lord and submit everything to the Lord. And what I appreciate you being honest, and I love you guys.
All right. Well, I'm sorry you're going through those other difficulties. I don't have any jurisdiction or ability to address those, but it sounds like you've settled on a course of action to bring yourself some serenity. So good luck to you in that, and you can leave the court. Good luck to you, sir.
Yeah, thank you, sir, and I appreciate your honesty. It goes a far way in the community, and we look up to people like you that makes a difference in people's lives. Bless your heart.
Thank you, sir. I appreciate that. You're all set. You can leave the court, all right?
Thank you, and have a beautiful day.
You too. All right. Mr. Sierra?
I don't know how to end it. How do I end it?
I can help you out with that, sir. 1 second. I gotta find this. Don't see us. Do you see us? Is he still in? I don't see his. Mr. Sierra?
We can